How to remove all negative items from your credit report for free. Next chapter is what to do with harassing collection agencies. People are convinced to make a small payment to a creditor that is harassing them, to keep them off their backs, so to speak. When the creditor or collection agency realizes the statute of limitation is approaching in your state, they are desperate to receive any kind of monetary value from you in order to keep the debt alive. This means that if you have a credit card debt and your state has a 4-year statute of limitation, when the 4-year mark approaches, if you pay even $1 to the creditor, you start a new 4-year of statute of limitation. It is either from the last bill paid or the new payment of $1 you made. This gives power to the creditor to sue you for another 4 years. If you didn't pay anything for the 4 years and the creditor sues you, you can come to court and throw it out by proving that the statute of limitation had passed, or send a certified letter to the attorney suing you requesting to cease the suit right away as it passed the statute of limitation in your state. A debt that passed the statute of limitation is also known as a zombie debt. Another way to stop the collection agencies harassing you is requesting a debt validation proof from a collection agency. By law, they need to provide it to you within 30 days. Next chapter, another way to remove negative items legally. Letter of debt validation. Under the Federal Debt Collection Practices Act, you are allowed to challenge the validity of a debt that a collection agency states you owe them. People neglect to request a debt validation proof from a collection agency. Collection agencies usually do not keep a written copy of your debt contract. They usually buy the debts in bulk for pennies on the dollar. If you are getting sued or being harassed by a collection agency, you write them a letter requesting a debt validation proof. I used it on one client when he brought the summons to me all frightened. The lawsuit stopped and the phone call stopped. It doesn't mean you don't owe the debt. It means there's a quiet period until the info is provided to you. Until this date, he never received one. Do not settle for a computer print. You want to see a written contract with your signature on it, date, amount, and all of detailed information. You have the right to receive it. If the creditor does not provide it to you, they cannot sue you or contact you until it's provided. This is a sample letter to the collection agency. Make the agency verify that the debt is actually yours and owed by you. Keep a copy of your files and send the letter registered mail with a delivery receipt. You want to put your name, date, your address, city, state, and zip, the collection agency name, collection agency's address, their city, state, and zip. You want to put regarding, account number, to whom it may concern. I am sending this letter to you in response to a notice I received from you on date of letter. Be advised this is not a refusal to pay, but a notice sent pursuant to the Fair Debt Collection Practices Act, 15 U.S.C. 1692 G, Section 809B, that your claim is disputed and validation is requested. Validation is requested. This is not a request for verification or proof of my mailing address, but a request for validation made pursuant to the above named title and section. I respectfully request that your office provide me with the competent evidence that I have legal obligation to pay you. Please provide me with the following: what the money you say I owe is for. Explain and show me how you calculated what you say I owe. Provide me with copies of any papers that show I agreed to pay what you say I owe. Provide a verification or a copy of any judgment if applicable. Identify the original creditor. Prove the statute of limitations has not expired on this account. Show me that you are licensed to collect my state, and provide me with your license number and registered agent. If your offices have purported invalidated information to any of the 3 credit bureaus, Equifax, Experian, or TransUnion, said action must constitute fraud under both federal and state laws. Due to this fact, if any negative remark is found on any of my reports by your company or the company that you represent, I will not hesitate in bringing legal action against you for the following: violation of the Fair Credit Reporting Act, violation of the Fair Debt Collection Practices Act, Defamation of character. If your offices are able to provide the proper documentation as requested, I will require at least 30 days to investigate the information, and during such time, all collection activity must cease and desist. Also, during the validation period, if any action is taken which could be considered detrimental to any of my credit reports, I will consult with my legal counsel. This includes any information to a credit reporting repository that could be inaccurate and invalidated, or verifying an account as accurate when in fact there is no provided proof that it is. If your offices fail to respond to this validation request within 30 days from the date of your receipt, all references to this account must be deleted and completely removed from my credit file, and a copy of such deletion request shall be sent to me immediately. I would also like to request in writing that no telephone contact be made by your offices to my home or to my place of employment. If your offices attempt telephone communication with me, including but not limited to computer-generated calls or correspondence sent to any third parties, it will be considered harassment, and I will have no choice but to file suit. All future communications with me must be done in writing and sent to the address noted in this letter. This is an attempt to correct your records. Any information obtained shall be used for that purpose. Sincerely, your signature and your name. Step 2. Once you have requested the debt validation letter from the collection agency and not received it, write back to the collection agency requesting the removal of the item from your credit report, as they are in violation of the FDCPA Section 809B. Step 3. If the collection agency removes the item, great. If the collection agency does not reply to your removal request, you're going to contact the credit bureau. You write to the credit bureau a letter requesting to remove the item from the credit report with a copy of the letter you sent to the creditor requesting to remove the item since no validation proof was given. I prefer to work directly with the credit bureau rather than dealing with the creditor or collection agency. In the past, it worked for me the best. If you are persistent, the credit bureau will be forced to remove those negative items permanently. It might not require another letter, but usually when they receive the FTC complaint letter warning, they delete this item, or they delete the items. Don't forget, the credit bureau receives about 10,000 letters a day. They are for-profit organizations. They want to be as quick and cost-effective as possible. That's why they send the complaint to cheaper labor countries and mostly use the e-Oscar electronic system. When the credit bureau sees a smart consumer, they would rather delete the item than risk receiving complaints with the FTC. At least that was my experience in the past years. Nevertheless, since the credit bureau do not follow the FCRA rules and fail to provide a solid, legitimate, detailed, verifiable proof to consumer most of the time, you are able to delete all of the negative items on your credit report legally and permanently. You can also sue them for a $1,000 penalty since they are in violation of the FDCPA Section 809B and FCRA 611A rule.